Good afternoon. I'm Jeff Shepard, and I'm here to welcome you to another one of our Nixon Legacy Forums. These are co-sponsored by the Richard Nixon Foundation and by the National Archives. And we're happy to have you here in the audience and to welcome our C-SPAN audience for later broadcast. My job is to also introduce our co-host, who's the Archivist of the United States, David Ferriero. He's a strong supporter of these forums, and we greatly appreciate the work that he's done. He's the 10th Archivist of the United States and a lover of knowledge and a keeper of all of our documents. David? Thank you again.
Once again, it's a pleasure to welcome you here to the National Archives this afternoon for another Nixon Legacy Forum, Nixon to Reagan, Reshaping the Supreme Court. In addition to everyone here in the McGowan Theater, we're delighted to welcome everyone watching on this live webcast. As Jeff said, this will be the 22nd in a series of legacy forums that we have co-sponsored with the Richard Nixon Foundation. Once again, a distinguished panel of some of the people who have helped make the history of the Nixon administration will discuss and analyze and reminisce, not just about the events in which they played a part, but about the important backstory to these events. It is that backstory that only they can supply that will be of special interest and importance to scholars as they write the history of those eventful years between 1969 and 1974. The Nixon administration was the most extensively documented presidency in our history. There are millions of papers, thousands of hours of tape recordings, and a large number of interesting artifacts, such as the naval uniform the young Lieutenant Nixon wore to the interview that led to his being selected to run for Congress in 1946, and the suit he wore when he was sworn in as president in 1969, the family Bibles on which he took the oath of office. For the last couple of years, since we opened a state-of-the-art archival facility at the Nixon Library in the summer of 2010, Yorba Linda is now the central place for worldwide Nixon studies. Scholars and students and interested citizens can go and learn about Richard Nixon, about the tumultuous and important time he was in the White House, and about his long and productive and very interesting and eventful life. 2012 is Mrs. Nixon's centennial year, and the Archives and Foundation presented an excellent exhibit, Pat Nixon, People Were Her Project, to mark that event. The library has also released some 75,000 pages of new material from the First Lady's office. January 9th, 2013 will be Richard Nixon's 100th birthday. On President's Day, February 18th, the library and the foundation will open a major special exhibit covering the 37th president's entire life from 1913 to 1994. I won't give anything away, but I will say we found some very special artifacts, some very striking photographs, and some never-before-seen letters and papers to illustrate various aspects of the former president's life, from warming the bench for 4 years as a 150-pound member of the Whittier College football varsity, to working in the Oval Office, to writing 10 best-selling books and becoming an elder statesman after he resigned in 1974. Today's Nixon Legacy Forum will be moderated by Kevin McMahon. Dr. McMahon is the John Reitemeyer and Charles A. Dana Research Professor of Political Science at Trinity College in Hartford, Connecticut. He's a brilliant young scholar whose most recent book is Nixon's Court, his challenge to judicial liberalism and its political consequences, which was published last year by the University of Chicago Press. Please welcome Dr. McMahon.
Thank you all for coming, and thanks for those watching on YouTube or on C-SPAN. Let me first introduce the panelists. First, we have Fred Fielding. Mr. Fielding served as Associate Counsel and Deputy Counsel to President Nixon and White House Counsel to Presidents Reagan and George W. Bush. Next is Wally Johnson. Mr. Johnson was appointed by John Mitchell as Associate Deputy Attorney General in 1970 and was responsible for managing Powell and Rehnquist confirmations before the Senate Judiciary Committee and also supported the second Rehnquist elevation to chief. And finally, Tom Korologos. Ambassador Korologos started his career in the executive branch as deputy assistant for legislative affairs in the Nixon and Ford White Houses, and later was tapped by President Reagan to manage the confirmations for Rehnquist and Scalia. Okay, so I'll start off just by giving a broad overview of the 1968 presidential election and the importance of the Supreme Court in that election. It's seen as really a fundamental election with regard to the transformation of the Supreme Court. Talk a little bit about some of the first appointments, and then we'll open the discussion focusing with, beginning with Paul and Rehnquist, appointed in 1971. So the election itself is, as many of you know, takes place in a very chaotic time in American politics. Democrats had been in control of the White House since certainly 1961 with the election of Kennedy. And with regard to the unrest that was occurring in the 1968, during 1968, 1967, for riots in places like Newark, Detroit, and the rise of crime that was occurring during that period of time, there was a great deal of a focus on the Supreme Court, particularly the Warren Court's revolution in criminal rights law. The most famous decision is probably the Miranda decision, right? So Nixon and also George Wallace, the third-party candidate, were able to use the court, which was an extraordinarily liberal court, to emphasize to culturally conservative voters how a Nixon administration would be different, right? Would take a different view on matters with regard to the court itself. And what made this particularly interesting was the fact that Earl Warren, after the assassination of Bobby Kennedy, became concerned that Nixon, who had virtually secured, had done quite well in the primaries, the Republican primaries, thought Nixon might become president, and therefore decided to retire. And this occurred in June of 1968. And while some Republican senators suggested that he not appoint a replacement for Warren, that the next president should appoint a replacement for Warren, Lyndon Johnson chose to do so and sought to elevate Abe Fortas to chief. And the Fortas confirmation became really a centerpiece for part of the campaign and allowed conservatives in the Senate to attack the Warren court through their questions of Fortas, many of which he didn't answer or gave evasive answers. Ultimately, Fortas is filibustered, right? His nomination fails. So once Richard Nixon is elected president, he understands that he has at least one seat to fill. And then I'll fast forward to May 15th, 1969, after putting pressure on Abe Fortas because of revelations about financial improprieties, Abe Fortas resigns from the court. So at this point, Nixon has two seats to fill in the court. Not only two seats that are filled by two of the most ideologically liberal justices sitting on the court, Earl Warren and Abe Fortas. His first appointment is with Warren Burger. There we go. So this is the day in which Chief Justice Burger takes the oath of office to be Chief Justice, and Warren is to the left, Nixon in the middle, obviously. So Burger is sort of a non-controversial appointment, wins pretty easy confirmation in the Senate from Minnesota, so that somewhat non-threatening, I guess, to others. The next appointment does not go all that well for President Nixon. He first appoints Clement Haynsworth of South Carolina. And Haynsworth is viewed by a Republican Party that is, you know, a much different Republican Party than we have today. In the end, 40 Republican senators oppose Clement Haynsworth confirmation to the court, despite the fact that Richard Nixon had run on this issue, promising to appoint strict constructionists to the court. And soon into his term, virtually half of his party in the Senate opposes that nomination. There were ethical issues that were emphasized, but if you look at the breakdown between liberals and conservatives, it's really a ideological vote. Haynsworth Nixon then appoints G. Harold Carswell of Florida, and Carswell also runs into problems in the confirmation process. Again, the Republican Party divides. About 32% of Republican senators oppose Carswell, really because they see him, those opposing him really see him as somebody who would go back on the civil rights record of the Warren Court. And finally, the third appointment, nearly a year after the Fortas resignation, is Harry Blackmun. Berger's Minnesota twin, as he's known, and he secures a fairly easy confirmation. So then if we move to September 1971, again, 2 appointments to the court. Justice Hugo Black resigns because of health reasons, and then John Harlan resigns also because of health reasons. And historically speaking, when there are 2 appointments when there are 2 vacancies, there tends to be more conflict because the Senate, particularly opponents in the Senate, can use one as sort of to say, see, we're reasonable on this guy, but on the other one, we don't like him for some reason or another. And what first happens is in September 1971, Nixon, if you're listening to the tapes, you can get a sense that he's really interested in making a politically powerful appointment. And he would like to appoint a woman and give serious consideration to a woman. Certainly wants to fill one of those seats with a Southerner. Hugo Black was from Alabama and was the last sitting Southerner on the court. And then there's also strong consideration to appointing a Catholic. And ultimately, Nixon settles on a woman, Mildred Lilly from California, and a Southerner, Herschel Friday of Arkansas. The release of those names does not get positive response in the press, to say the least. And he reconsiders and focuses much more on quality. And that's when he settles first on Paul, will be his Southerner, a very respected attorney from Virginia, and then William Rehnquist, a young conservative in the Justice Department from Arizona. So let me stop there. We'll pick up the discussion. We'll talk about the preparation and the confirmation of the justices, and I'll move over here. Thank you.
Thank you, Kevin. Let me segue into the part of the conversation that we're going to have here with the panel. As you are aware, we're discussing the constitutional powers of the president under the Constitution to fill the Supreme Court with the advice and consent of the Senate. What I'd like to discuss briefly here is the evolution of the process for judicial selections and for the vetting that goes into that, and then we'll move on to the confirmation hearings. I should preface my remarks by saying, although they obtain generally to all the federal judiciary, and candidly a lot of the ideological battles are fought at the district court and more realistically at the Court of Appeals levels as far as appointees go. Nonetheless, this process is the same, but it's accentuated when you're dealing with the Supreme Court. So what I'd like to do is basically just talk briefly about the role of the executive branch as it contributes the name and as it interplays and intersects with the legislative branch as far as the advice and consent process goes, and the interplay also of the Justice Department and the White House in that process from the executive branch point of view. And I'm just going to give you pretty much a broad brush because, as I say, I want to go over the evolution of the process. We all certainly know of recent Supreme Court hearings, and it may be a surprise to the audience listening today and watching today, but the first televised hearing was Sandra Day O'Connor in the Reagan administration. And we're going to really concentrate today on the difference and the evolution from the Nixon administration through to the Reagan administration. But that was the first televised hearing of what we all now assume is part of the fare that comes with these appointments. What you may not realize is the history of confirmation hearings is that the hearing itself is a relatively new phenomenon in the history of our country. I did a little research and found out that Harlan Fiske Stone was the Attorney General of the United States, and when he was nominated, he had one question in his nomination hearing, and that was a question by a senator who wanted to understand why he had tried to prosecute that senator. But then there was a little hiatus before the next real confirmation of any controversy took place. And it's interesting to note that up until the mid-50s, they really did not have contentious hearings. They had perfunctory hearings, if hearings at all. And then in, I believe, in 55, the question of who was to become Justice Harlan was really grilled about his role and his understanding of Brown versus Board of Education. But as we all know now, and especially with televised hearings now, this has become quite a ritual that we all go through and we all watch. And it's kind of a dance, candidly, because everyone anticipates and everyone looks for the flaws and everyone looks for the tilting and the piercing questions and that sort of thing. I'm afraid, although this is totally an aside and personal, I'm afraid that maybe the purpose of having these hearings has bypassed us because I'm not sure how much really comes out of the hearings. In the beginning, and in the beginning of the Reagan administration, certainly, some of the questioning was very precise. And then came the Bork nomination, which we will be discussing later. And there's been subsequent to the Bork nomination, there are very, very few nominees that will answer any question that is directly related to a potential future case. Because they know and they've learned from the Bork experience that the question may or may not be there to educate the senator and the public, but it certainly has caused havoc in disruption in the hearings themselves. And again, I'm not passing judgment as to whether that's good or whether that's bad. I think it's just a fact that we all have to face, that that's what these hearings have turned into. A few brief words, if I may, on the selection process. And again, a little history to it. In the Nixon administration, and certainly in the beginning, the decisions for the selection as well as the vetting of these people, of the candidates, really was primarily the responsibility of the Department of Justice. And the Department of Justice, in particular, was the Office of Legal Counsel, and it was the Deputy Attorney General and the Attorney General with the White House at the highest levels. When I first went to the White House, John Dean was the counsel of the president. He was not consulted, but John Ehrlichman, who had been the prior counsel, was in some of the consultations for Supreme Court. And then after the unfortunate circumstances we just heard about as far as the Nixon administration was concerned, they put John Dean and another young lawyer on the road to go interview people around the country, to come back and then report and give their observations to, again, the Attorney General and to the President and his two top advisors at the White House. Now jump forward from that to the Reagan administration, and here's where there was a sea change. Ronald Reagan had been upset that some of his appointees when he was governor had not turned out the way he had hoped they would turn out as far as the philosophical bent that they showed on the bench. And so he wanted to bring the process of the selection and the vetting into the White House itself. And so he set up that as his wish. Of course, we understood his wish was his command, of course. And so I chaired a meeting that met once a week in the White House. The Attorney General and the Deputy Attorney General were invited as in addition to the head of the Office of Legal Counsel and the Office of Legal Policy. And they met with a series of assistants to the President and that I chaired once a week. And we reviewed every vacancy, every federal judicial vacancy. And week after week, you would get further reports as to where they were doing. A lot of the pre-vetting was, in fact, done. It's still done at the Department of Justice. But the selection process was literally moved into the White House. And that's a practice that certainly obtained in the Bush 41 administration and certainly did in George W. Bush's administration. And I assume from observations and from being on a Miller Commission that it carried through Clinton as well. So now you have a different phenomenon. Now you literally have this selection process moved into the White House. Now, as far as the vetting goes, that is done to make sure that there aren't horrible things in the background, to make sure that we understand, we who are reviewing the candidates, what the potential pitfalls may be. But to get back to our new phenomenon where we then have, especially in the Supreme Court nominees, you have this public hearing process that has to go through. Now you've already vetted, so you know if there are potential weaknesses in the candidate. You know, you tell the candidate, basically, if we make a decision, you tell us everything that there is to know about you. You make a decision. We'll make the decision as to whether we go forward. If we go forward, you're our candidate. If you don't tell us and it comes out, we don't have that same obligation. And that usually brings out the facts when people want to go for these sorts of offices. But we have now the advent, because especially in the Supreme Court situations, we have the advent of what I would call the super Sherpa. This is the person who will then lead that candidate through the process, especially in the Supreme Court. And these are the people that are going to tell you how the super Sherpas operate. So I think at this moment I will turn this over to Wally and to Tom, because let me make one further comment. With all the vetting and all the care that goes into selection, the preparation of these people for these hearings is the most crucial. That's where the decisions have to be made, and that is where the defining moment becomes, because these people have to be prepped to withstand what we've all observed. And so with that, I will turn it over to Super Sherpas.
I've never been called a super Sherpa.
Well, I'm sorry.
My part of the story starts the day Bill Rehnquist was named by the president, and there's plenty of written history about what happened in selecting him. But I was Associate Deputy Attorney General, and that meant basically I was legislative counsel for the Department of Justice. And before I get into some conversation about the specific process and strategies we pursued with the Powell-Rehnquist confirmation, and then talk a little bit about Rehnquist too, 15 years later when he was named to be Chief Justice. I'd like to go back to Kevin's book, because there's a paragraph in Kevin's book that really creates a pretty clear picture of the atmosphere that we were living with in 1969, 70, and 71. And I'd like to just read it. Now, we're all given 6 or 7 minutes for our opening remarks, and I argue that I shouldn't have to do this because it's taking time away from what I'd really like to talk about. But this is so critical that I think everybody should really focus on it. Specifically, by the summer of 1968, the court's recent rulings had aided communist forces, abetted criminals intent on causing harm, threatened to dislodge school children from the security of their neighborhoods, unleashed a wave of pornographic smut, released murderers from death row, forced prayer out of the schools, and loosened society's constraints on sexual promiscuity. In the next few years, the court would provide more fuel for these fiery critics by, in their eyes, sanctioning the splitting of the national military, the spilling of national military secrets, allowing anti-war messages into the nation's courthouses and classrooms, giving free rein to those denouncing the authority of the badge, encouraging women to devalue their traditional role in American life, beginning the process of guaranteeing those unwilling to work a monthly check, and unleashing a massacre on the nation's unborn. It did it all moreover in the name of the Constitution, a document nearly 2 centuries old, but interpreted by the court's 9 unelected wise men to keep up with the times, to live even through its drafters had died long ago. Now, that's the world within which Bill Rehnquist and Lewis Powell were nominated. And Kevin gave a very succinct preview of the atmosphere that existed before that. As Associate Attorney General for legislation, I was in charge basically of handling the Department of Justice affairs on the Hill. I worked with the Senate Judiciary Committee. And in those earlier hearings, I was one of the young fellas sitting behind the senators, along with some of you during those times. But when John Dean went to become legal counsel to the president, I moved back into the department and ran the legislative office. Now, a word about how that all structures, because it'll fit into what Ambassador Korologos and I ultimately talk about during the dialogue. Every department has a legislative affairs office. And there's the White House, which also has an office of legislative affairs, and that's where Tom Korologos worked, and he and I were partners. I ultimately went and worked more directly with him as a special assistant to the president, but it was after the period of history I'm talking about here. And as Fred pointed out, Bill Rehnquist, in his role as Assistant Attorney General in the Office of Legal Counsel, was the guy that marshaled the nominations that were unsuccessful. And I can remember Bill, and I think Fred, you probably have a similar memory. He had a bad back, and in his office in the Department of Justice, he had a lazy boy chair. And was always surrounded by law books. And he wore hush puppies. And I can remember very clearly going in to see him, and he couldn't get out of the chair because his back was so bad. But what we did probably differently during the Rehnquist-Powell process than happened before was communicate. There was some, I won't say this in an arrogant way, there was some genius to the way we did it because it was not how it had been done before. It was a process of communication. The relationship between the Attorney General, who was John Mitchell, James O. Eastland, who was chairman of the Senate Judiciary Committee, and Roman Hroska, who was the ranking minority member, was so tight that what one knew, they all knew. So basically, as the associate deputy, the super Sherpa, I would spend my time talking to each one of them, and then with Bill, to be sure that we had coordinated the strategies. Now, having said that, and I will talk more about this when we get to it, but we had almost God Almighty being nominated in the form of Lewis Powell. Everybody wanted him to be confirmed, and nobody wanted Bill Rehnquist to be confirmed. Why didn't they want Rehnquist to be confirmed? Because he was young, and he was smart, and he would be on the court for a long time, and his views were not unknown to those who were involved in the process. He's a very conservative, law-oriented guy, and for every one of Kevin's observations about what was going on in the country, Rehnquist had an answer that would satisfy President Nixon, James O. Eastland, and Roman Hruska. Now, with that in mind, we pursued a strategy. And the strategy basically was to never let Powell get in front of Rehnquist. And I can remember conversations held in Senator Eastland's office with Powell, who was just a wonderful, wonderful person. And Powell would acknowledge, I could see him drooling to get confirmed. The world wanted him confirmed. The New York Times wanted him confirmed. The American Bar Association wanted him confirmed. He wanted to be confirmed, except the second there was separation was the second there was a problem for Rehnquist. So we just never let it happen. We always kept Rehnquist in front of Powell, so that when the committee acted, if it didn't act on Rehnquist, it wasn't going to act on Powell, and the pressure built up, and in effect, that's what allowed us to move forward with Bill Rehnquist. Now, when I talk about communication, it wasn't always easy, because a lesson I've learned, and I heard it first from Ambassador Korologos, never do directly what you can do indirectly. And the fact is, many senators act that way. And so my day during this period of time, this 2 months, when we were processing these two very eminent jurists, would start by having breakfast with Senator Eastland and the senator in the Senate dining room, and he'll say, "What's going on?" And I'd tell him what the Attorney General thought. And then we go through the day. I talked to Tom, who was my liaison at the White House. I talked to Hruska. I'd go and sit with Eastland almost every night, because he would have a glass of scotch at about 5 o'clock. The only problem is he didn't talk. He was the most silent person I've ever met in my whole life, and we'd sit there and look at each other. And we'd look at each other, and then he'd say something like, "What do you think Phil Hart thinks?" And I said, "What, Senator, what?" He said, "What do you think Phil Hart thinks?" What he was saying was, "What do you think Senator Phil Hart thinks?" What do you think Phil Hart thinks? And after I interpreted this, I'd say, "I'd better go find out." Well, I talked to Bert. We'd work all these things out in a way that each one of these partners that represented the president, that represented the Senate majority and the minority, knew exactly what each other were thinking. And they were able to devise strategies that resulted in a successful confirmation. Now, I left Washington, but I left behind some very good friends. One of my good friends was Justice Rehnquist, and another of my good friends is sitting to my right, Ambassador Korologos. And when, after about 15 years, Bill was elevated to be Chief Justice, I was back in Washington, and Tom and I met with Bill Rehnquist and with White House representatives and with Justice Department representatives. And while Tom was the person in charge of marshaling this nomination, I was here as Bill's consigliere. But mostly we did what we've done for many years in working in the Congress, and that is communicate. Before I pass it on to the ambassador, I'd like to say that Bill Rehnquist was in fact a fine constitutional lawyer. But I don't think Bill Rehnquist knew that he was going to be the foundation of the interpretation of the advice and consent clause as it has now become. Because back there in 1968, 69, and 70, the Congress changed the way in which it began to examine these nominees. And there are lots of different historic factors that play into it. But they asserted themselves. So what we'll be talking about and what I have seen written about quite extensively, particularly in a recent book by John Jenkins called The Partisan, The Life of William Rehnquist, is this discussion of what's the role of the Senate? What's the role of the President? What does consent really mean? And what does advice mean when you don't talk directly? And on that profound note, I'll turn it over to my good friend, Tom Korologos, who's never left Washington.
Well, he's right. 50 years this year I'll have been in Washington. I can't believe it. But what over the years, as Wally has said, I have become involved in, I'm going to count them sometime, probably 300 or 400 confirmations, various confirmations, from the director of the Bureau of Land Management to the Supreme Court justices to vice presidents of the United States under the clause where they have to be confirmed by both the House and the Senate. And I'm called by individuals and by the White House to do this. This is all done pro bono, by the way. The only pay I want is to go to the swearing-in ceremony and smile. But what we bring to the party, the Wallys and the Korologoses of this world, is a knowledge of the process, a knowledge of what works. Generally, a confirmation process is unlike anything the person has gone through before. Yes, he was a judge. Yes, he was confirmed by the Senate. Yes, he may have been an important businessman or what have you. But the confirmation hearing and that ritual is something that is a fairly different kind of world. And we are intermediaries. We bring to the party what senators think and what White Houses think. Half our time is spent explaining the White House to the committee and the committee to the White House. Never the twain meet. They're one of them down here downtown, the other one's on the Hill. And as Wally said, not only don't they speak to each other, but when they do speak, it's like Casey Stengel speaking. You got to not only interpret, boy, what did that mean, let alone translate it. And we were the translators trying to figure this all out. We talk and work with various staffers. We find out what's on the senator's mind, what's ticking. One fast story, when we were assigned to do the Bork confirmation, Senator Thurman was one of the leading, was on the committee, and he had two staffers on the committee that kind of competed with each other. So I said to him one time in a meeting with a bunch of senators, well, Senator, with whom are we supposed to work? And there was total silence because everybody knew what I was driving at, and he said, both of them. So all of a sudden I'm refereeing these two warring staffers who wanted a piece of the action. The goal is to get 51 senators to approve the nomination. You're not running for sheriff. You're not running for popularity, miscongeniality, or what have you. You're running for 51 votes to get there. And short of a declaration of war, a Supreme Court vote by the Senate is probably the most important vote they will cast in their entire career as senators. And they take it very seriously. Some numbers. The Senate historian tells us that 160 nominations have been made to the Supreme Court since 1789. 18%, roughly 1/5, didn't make it. Now you compare that number with 4% of nominations that didn't make it through cabinet to have been turned down by cabinet appointees. And as Wally and Fred and Kevin said, in the early days, the name went up, confirmed by the same day. Bang, right now. And then the recent averages are about 2 or 3 months to go through the thing. And what happened is we got into the liberal and conservative nature of the court and what is going to be the judicial philosophy if this man or woman makes it. Well, let me cite you some interesting little data points which has already been talked about. Nixon's appointees: Berger, Vice Warren; Blackmun, Vice Fortas; Powell, Vice Hugo Black; Rehnquist, Vice Harlan, and toss in Hainsworth, Carswell, Scalia, Bork to follow. And you see what I mean about the name changing the makeup of the court. And I'm here to say every appointment changes the judicial philosophy of the court. There are only 9 people on it, one more, pro or con, and then you've got to figure out what's he really going to be like. And there can be examples of very conservative justices on the circuit or very conservative justices to be in the hearings, and they get on the court and there's something else. So you've got to factor that in. And what happens immediately when the Fred Fieldings of this world and the Wallys get through and the Attorney General and the President and the staff finish their vetting process, suddenly the name leaks. And who's going to be the next judge, the next justice? And suddenly war rooms are created around the town and on the Hill. And they start looking at the health record of the potential, the high school yearbook. What did he say in his yearbook? Thank goodness there weren't emails back in those days. The Sunday school teacher is interviewed. The neighborhood civic association where he belonged. Deeds on homes are looked at. We had an issue with Justice Rehnquist. There came up at the hearing a deed on a covenant on a home that he had bought, a beach house, I think it was. Wasn't it, Wally? Up in the mountains. He had a home that he bought, and he signed the thing. And somebody checked the covenant, and inside it said, "This house will never be sold to anyone of the Hebrew faith." Well, in the first place, there's no such thing as a Hebrew faith, as was pointed out in the hearing, and it became an issue. Why did you sign this terrible deed? You were a lawyer, why didn't you know that? Well, how many people in the world have ever read the covenant on their home? So what we did is we went and found the senator's deed on his home. Oh, isn't that interesting? Here's the same covenant. Well, that ended that argument for a few minutes. Voter registrations are looked at, and every one of them looking for the elusive law review article while he was in law school that might shed light on the legal philosophy. Pretty soon, sometimes, depending on how contentious it is, advertisements start. Gregory Peck starts cutting commercials. Polls are taken. Candlelight vigils are held. And the Wally Johnsons and the Korologoses of this world step into this war without flak jackets and try and make sense of it. Judge Bork. The White House asked me to help Judge Bork, and they said, I went down and they said, "Can we get him confirmed?" And I said, I went something like this, yeah, we can get him confirmed. And they said, "That's not good enough. Can we get him confirmed?" And I knew Judge Bork. I knew his record. I mean, he wrote the antitrust book at Yale. He was 100% qualified under the American bar when he went to the district. Brilliant scholar, brilliant everything. And they said, yeah, we can get him confirmed. And boy, was I wrong. First thing that happened after the appointment, Senator Kennedy stood up on the floor and talked about back alley abortions. Back alley abortions will be back, and restaurants will be segregated again. And he kicked off the war, and and it went downhill from there. And I should tell you, on the side, after Senator Kennedy said that, I ran into him in the hall, and I said, I'm putting you down as undecided. And we both kind of laughed at that for a minute. The problem with Bork was that he was a conservative. And he was Attorney General under Nixon when they fired Saturday Night Massacre. He was Solicitor General under Nixon. And also we had a perfect storm. The Democrats had just won the Senate. That had previously been Republican. And that Republican Senate had confirmed three appointees, three Reagan appointees: Sandra O'Connor, Rehnquist, and Rehnquist for chief, and then and Scalia. So now the feeling was that's enough. And pretty soon we started the hearings. They went on 5 days, nonstop. We even had a hearing on a Saturday. Everybody wanted to go, a beautiful Saturday day. Complaints came in about why are we having a hearing? Well, Senator Specter and Senator Justice Bork were arguing about stuff. During the process, advertisements appeared. People came up to me and said, why aren't we buying ads? And I said, because the Constitution says that it's an appointment. It's not an election. People aren't voting for this appointment. It is this advice and consent of the Senate. We don't need to make it a political thing. If they wanted to make it a political thing, they'd have put it in the Constitution. Issues came up. He had this weird beard, as you can see in the picture. Where that came from, he broke his arm somewhere, and like happens to us, happened to me one time. I grew a mustache, and people thought it was crazy. And so here this weird beard appears, and his picture's in the paper with his beard. And three senators came up to me and to him. The hearing was, I can't remember if it was on a Tuesday or a Wednesday, 2 days before the hearing, and said he's got to shave his beard. That's terrible. We can't have that. Well, during the process and during some of his statements, he was accused of confirmation conversion, to changing his philosophy in order to get confirmed. And he said to me, what do you think? And I said, you shave your beard. That's the ultimate confirmation conversion. Here we are yesterday, your picture's in the paper, and tomorrow you're at the hearing without this beard to get confirmed. No, we can't do that. So his beard stayed, and so I was accused of not helping the process along. Well, anyway, finally we lost 58-42, and it was really a terrible injustice of the long time. I mean, the American bar gave him unanimous thing when he went to the district, and all of a sudden 5 members of the bar said no, not qualified. Well, what kind of stuff was that? Pretty soon we go to Rehnquist 2, and the president is going to nominate him for chief, and I went and saw him. And I said, here we go again. And he said, well, let me ask you something. Why do I need a hearing? I said, what do you mean, why do you need a hearing? He says, you have hearings to see if you're qualified. He said, Tom, my opinions are there. They have been written. They can study them and look at them. I'm not going to second guess everything I did in those opinions. And I'm not going to telegraph what I'm going to do in any future opinions that might be coming before us. So why do we want a hearing? Well, it occurred to me he was serious. And I said, okay, calm down now, Bill, here. Let's go. And so we started our strategy sessions. We started the usual courtesy calls and his hush puppies. And we prepped senators for the hearing. And we conducted murder boards, which is a phrase we coined. A murder board is a mock hearing where we go in and ask the rottenest, worst questions that we can possibly ask, making sure that we hope we have asked every question that can possibly come up in the hearing. And you know you're a success if at the end of the hearing the nominee comes up to you and says, you were infinitely worse than they were. Well, that's the point. We want to, the thing we say to them is what Fred said at the beginning. What is there in your background that you have done that's going to embarrass the president and embarrass you? Now, I'm not asking you to tell me, but get an answer, because SOBs on the Hill are going to ask it at a hearing. So get something going. I'm going to tell a fast aside story. I said that to a guy one time that was up for a job somewhere, and he looked at me and he said, "How do they know that?" I don't know whether it was an axe murderer or what, but he withdrew his name when I asked that question. But anyway, you say to the nominee three things, three major things. Your role in this process is that of a bridegroom at a wedding. Stay out of the way, be on time, and keep your mouth shut, and we may make it. The other thing I say to him, and we say to him, is you must follow the 80-20 rule. The 80-20 rule is if they in the committee are talking 80% of the time and you're talking 20% of the time, you're doing right well. If you're talking 60-40, that means you're arguing. And if it's 50-50, you've lost. So let them vet their criticism and let them have at it 80% of the time, and we're doing right well. That is a plus. The third thing we say is the hearing isn't about you. It's about them. And you can see that in these hearings when we have justices or their televised hearings. Everybody will be given a half hour to ask questions. Each senator will go down the line and ask you to ask your questions. Well, some senators take up the whole half hour. And at the end of the question, say to the nominee, "What do you think of that?" And you have 1 minute to answer, "What do you think of that?" A quick aside, what little thing we say to that is you say to them, "That's a fascinating point you make. That's interesting. I hadn't quite thought of it that way." You haven't agreed with anything. You just found it fascinating, interesting, and a good point. So those are some of the things to say. The other thing that I've written it down so I can remember it, I say, all your statements must take on the passion and enthusiasm of a commencement address, inspiring, lofty, and at the same time say nothing. Because you cannot telegraph what you're going to be saying. And what the Wallies and I of this world do is we see how it's playing. Even in the murder boards or in the hearing, we see how it's going. If we don't understand the answers and we don't understand what they're trying to get to, the senators certainly aren't going to understand it. And that's not an attack on the senators, but it is on some of them. We don't get into original intent and Griswold and Roe v. Wade and what have you. We kind of hopefully steer them away from any commitments on what they may have said. Did the president ever talk to you about how you're going to vote on Roe v. Wade? Well, no president asked that. I hope, Fred. And one of the problems with the murder boards and Sherpas is that too many times we are cowed by the brilliance and knowledge of the appointment and of the nominee, and you tend to say, "Gee whiz, can I step in?" Well, I've gotten to the point, I don't get paid anything, they can't fire me, so I do jump in. I've gotten to the point of grabbing nominees by the lapels and say, "Now, you want to get confirmed? Well, then answer the damn question. And shut up and listen." And you kind of temper that a little bit with the justices. I get close with one fast Nixon story. After the Bork hearing and vote, it was 1987. I was on Nixon's call list for Christmas, and he called me and he said, "I got a question to ask you." I said, "What's that, Mr. President?" He said, he wasn't president. He said, "I want a list of all those that opposed Bork. Confirmation hearing, the groups or whoever. I want an entire list. Can you get that for me?" And I said, "Sure." So I got it, and I sent it to him. I said, "What do you want this for?" And he said, "Well, I'm busy making my contributions, my annual Christmas contributions. I don't want to make sure none of those bastards that opposed him are on my list." And that's what he wanted the list for. I close.
Thank you.
Kevin, can I jump
sure,
in and
sure.
just add something to Tom's observation? I'm going to Rehnquist 2 now, because my first memory of that experience after Bill and I and Tom and I and Bill and Tom and I sort of organized ourselves was a meeting in chambers where there were representatives of the legal counsel's office, both at the White House and in the Justice Department. And it is a trial. There are 100 jurors, but there are no rules of evidence. And as Tom points out, you got to get 51% of the votes. Now, having said that, a sitting judge, doesn't have any lawyer. He's all by himself. And with then Chief Justice Rehnquist, we could see how he was being tugged because everyone thought they knew what he should be doing. And one of the roles we played in Rehnquist 2 was as steady heads, had a sense of what was going on. Korologos knows everything that's going on because he was up there talking to the chairman, the majority leaders. It's information accumulation a lot. But the fact is we took that information and tried to help Bill understand how he should comport himself before that committee. And it's a fine line. It's a very tough thing to do because it's combat. And you just have to keep a steady hand on the tiller. One of the last conversations I've had with Judge Bork was when I talked to him after his nomination, before he went to the Hill, and I said, be sure you have someone advising you privately because they'll rip you apart. In other words, you need a steady consigliere at your left hand. And so I wanted to add that to Tom's observations because it is stressful.
Right. But, sure.
Let me just add something else to Tom's comments. Tom, you said you felt bad because you misjudged and thought you could get Bork confirmed. When we were in the White House making up our wish list of who we're going to send up, of course you do it and prioritize it as well. And if you think you were wrong, we went with Scalia before Bork because we thought Scalia was going to be the tougher of the two.
Yeah. It had been the other way around, Bork would have made it. Because we had a Republican Senate, and there was no way they were going to turn down the nice Italian boy who was coming up next.
Right.
So when do you know, I guess that's one place to start, when do you know that we might have trouble getting this person through? Or is it something that is, obviously in this case, it wasn't easily predictable, but with Bork, you probably suspected that this was going to be a tough one.
Well, what happened on that one is I thought we were doing fairly well until they started taking polls of the southern senators, of the southern states. And indeed, the campaign against him started picking up steam. Mm-hmm. They had just finished a bunch of civil rights bills and civil rights laws, and we're back okay, and school segregation had ended, and the swimming pools, and the thing got loose in the land that this guy might return us to some of that stuff that was so bad. Right. And I remember there was a poll taken, and it was above the fold on the front page of the Washington Post, below a photograph of something, and it said, poll shows Bork losing in South or something. And people started picking that up a little bit. And I felt we started getting in trouble when guys like Senator Heflin from Alabama, Senator Bennett Johnson, Louisiana, and then guys like Specter from Pennsylvania, who really should have been with us, started going soft. The Specter thing was remarkable. He was one of the more brilliant senators that you ever can come across. You had to study when you went in to see Specter. You better be right. Well, Bork was the Einstein of the law, and Specter was the Einstein of the Senate. And they sat there in those hearings going back and forth like two trains in the night, talking about constitutional theories and original intent and what have you. It was a remarkable experience to see this before my eyes. But we weren't getting anywhere. So one of the breaks, I said to Bork, why don't you let's get off of this. This is going nowhere. We're now on our 4th or 5th day. And that's when I told him, go out there and say to Specter, boy, that's an interesting point you make. It's fascinating. You know, you haven't agreed with anything. And he said, well, okay. So he goes out to the hearing and he says, Senator, I want to say that's an interesting point you make. It's fascinating. It's interesting. And then he says, but. God, here we are again. Another day of hearings. And other senators had yielded their time to Specter because this extravaganza was going on in front of their eyes. So we started, it started getting sour. We even went so far when I saw it was going bad in the committee of getting a vote out of the committee, let the Senate decide. Okay, usually when a committee votes down a nominee, that's it, good night. But this one we said, you must let the Senate decide. So they did send it to the Senate. And then there were attempts, there were inquiries about should he withdraw. I even had a call from the White House that said maybe he ought to do the right thing. And I blanched because they saw it fading too, to which point I said, no, to hell with you. We're going to make them vote. They got elected to vote. And let's suffer the consequences of voting down this thing. Right. And they voted, and of course we lost.
Right. It gets pretty interesting because during our time there, and Tom's still quite active, but 20, 40 years ago, we could look at 100 senators. This was our business.
Right.
And if we knew what 3 people were advising them could tell you how they could vote, I could close my eyes and tell you how the senators would vote. Now, Jim Eastland was a master. He was elected to the Senate the year I was born. So he was no spring chicken up there. And he was a man of few words, but he also, 2 of the words were, when he knew he had the votes, he'd say, let's vote. He wasn't saying anything until he knew he had the votes. So basically, counting the votes was the magic of what we did. And on Rehnquist 1, I would talk to Tom every day, and he would talk or get the message to the president. I'd also talk to Mitchell every day. We knew what and where the votes were. So we pretty well had a good count of the votes, and the tactics were designed to get a vote when we knew we had the votes.
Did much change between within the Senate between the first Rehnquist nomination and the elevation to chief?
I think what happened was, and I keep thinking about what does advice mean and what does consent mean. Those are key words, and when I said Bill Rehnquist established a constitutional principle, well, we know what President Nixon and John Mitchell were talking about, and we know they didn't call the Senate. They decided almost on the spur of the moment with Powell and Rehnquist. But the fact is, by the time we get to Rehnquist 2 and then Scalia-Bork, there was this unconscious acknowledgement of what advice means. Now, the fact is it went downhill fast with Bork.
Oh, yeah.
Just went downhill fast. And I wasn't there, but we almost lost control of the ability to manage the voting process.
Right.
Because the way in which nominations were contested changed rather dramatically.
Beginning with Bork.
Beginning with
right.
Bork.
Because that's a lot of people point first to Fortas, right? And you have the Fortas episode, and obviously the rejection of the 2 Southern nominees with Nixon, and then comes up again with Bork. And with Bork, obviously, we know that the significance of the Powell seat, right? The thought to be the swing seat was part of the reason why that was so controversial. But in terms of the vetting process, you said you decided to go with Scalia first and then Bork second. Could you elaborate on that a little bit? I mean, what was going into the thinking?
Well, we were trying to decide, as was alluded to earlier, which of the 2, since they were both eminently qualified, which of the 2 would be the more difficult as a nominee to get through a confirmation hearing. And our conclusion was that Scalia would be the much more controversial of the 2. And so we positioned it so that he would go first, never dreaming that the firestorm that would come up later on. And there was a change in the Senate, to be sure. But even without that, I think we would have stuck by our guns with the feeling that Scalia would have had a more difficult time in handling the whole thing because of the attacks would be made on him than Bork.
And could you elaborate on how much role the president himself plays with regard to either the vetting process or the confirmation process? Are they usually involved or not so involved once they made?
As a guardian of the executive privilege and communications with the president, let me just say the president's very involved. Okay.
Right.
Of course, I mean, it's a really important element of a presidency. And as Richard Nixon said, after he left the presidency, that those four were the most important long-range things. And if you look back, I mean, basically at the Sandra Day O'Connor appointment, when the president announced her, he talked about the footprints on the sands of time. That is the way the presidents look at these things. This is their legacy. Long after they leave is the imprint that they leave on the third branch.
And we used to go so far as to give the president names of undecideds, or someone had said, okay, quick, put a phone call in, lock them up.
Right.
Well, thank you for your statement in support of X, the Rehnquist board, or whatever. Two numbers for the record. The first Rehnquist 1 passed 68 to 26. Rehnquist 2 was a deterioration, lost 65 to 33. Now that isn't much, except when I told him, he said to me, how many votes are going to be against me today? I said, about 33, a third. What? How can that be? And he was aghast. But like Wally said, he was a policy wonk. He wasn't a politician.
Right.
He read cases. I mean, he read books.
Right.
And that was what he brought to the hearing.
Well, the other thing he was brilliant. Now, to do what we did, you have to be peasant crafty. You can be brilliant, but you have to understand the sense of the body with which you're dealing. And there are all sorts of different people in the Senate. And we're only talking about the Senate, not even the House, but it's a very complicated body. So in order to manage the 51 plus 1, or 66, 65, you basically have to work with the minority leader. You absolutely have to have the support of the chairman and the ranking minority member of a committee. And then there are little groups. And the idea is to coalesce those little groups around the nomination. Now, when you get right down to it, the minority and the majority leader ought to be able to hold their people if they've got the senator who is the chairman and the ranking minority member. And the nominee can't do anything to shake that coalition. And I speak to the Rehnquist issue and not the Bork issue. Preparing that witness was critical, because a senator could say, I don't accept that answer. You can't not remember. What do you mean you don't remember? And Bill was a master at holding his coalition together while basically not being tagged with some of the criticism that was leveled at him. I think I said that the right way. Because if you're Teflon, you can get away with it. Now, there are lots of reasons why with Rehnquist 1 it happened. Part of it was this movement to let's get this behind us now with Powell.
Now, can you just elaborate on what the discussions with senators, individual senators, are like? I mean, is it something that when you go in and have a meeting with an individual senator that you feel you could lock up his or her vote, or is it just sort of a calling and hello, how you doing? Nice to meet you.
Well, one of the things that I've done through the years, and it's sort of worked pretty well, is you got to be a little careful. Each one of them you treat differently. You treat the John Stennises and the Jim Eastlands and the John Towers differently. You know, you go up to Tower and you say, hey, you old goat, you going to vote with us tomorrow? And what are you talking about? You know, so you have this little tete-a-tete. With Stennis, you're very orderly, and you're very, Mr. Chairman, and can I discuss with you this matter coming up?
Mm-hmm.
And then what I do that has worked for me, and I'm telling trade secrets, is I say, what advice do you have on how we ought to be doing this? And what do you think we ought to, where we ought to be going with this? What do you? I used to have breakfast with him in the Senate dining room a lot. He'd sit in the corner, and I'd go sit over on this side talking to a couple other senators, and he'd wave me over. And I used to do it on purpose, and we had this little relationship that you did that. Some you use the local angle, not so much on Supreme Court nominees. A quick aside, the problem with Supreme Court nominees is that they're not pork. It's not a viaduct or a bridge. It's an ideological, important vote that the senator is going to take. And the thing that happens, or doesn't happen, is in the end, I can't tell you a senator has lost his seat for a vote on a nomination, a Supreme Court, or any nomination. It doesn't play in Utah. It doesn't play in Ohio. I mean, other things play. So you don't have any leverage. You don't have anything to give them. So you play on their, you know how their proclivities have been. You know how they voted before, which is what happened to us in a perverse sort of a way with the Southerners on Bork. How those people can suddenly turn on Bork because it played that he was going to be what he wasn't. And he had turned, quite frankly, the other thing I should say about Bork, and if he's watching, he's going to kill me, he did a lousy job at the hearings. He didn't schmooze. You'd go in and see a senator on the courtesy call. One time we went and saw Senator Weicker. It was very stormy outside. And it was late. Oh my gosh, gee whiz, how did you get in this morning? No schmoozing. We suddenly start talking about USC 34-7, you know, like the weather was part of the Constitution. He was, it was not, never mind what we tried to grab him by the lapels. We tried to, you got to humanize the nominee. You got to, we look what happened with Justice Roberts. Remember the adorable children that upstaged President Bush at the announcement? Oh, wasn't that nice? And then the other night, I wrote a piece for the Washington Post on humanizing the nominee, and they sent up Sotomayor, and she humanized herself by falling on the ice and breaking her arm. And she's out there with a sling. Oh my gosh, that was her humanized moment.
Right.
So there are all kinds of little things and tricks and what have yous that you do that play into these things. You don't know how anybody's going to vote. You're surprised a lot, and the Bork vote surprised me a lot.
So do you think it would be different without TVs, and to what extent, you know, in terms of this humanizing process, if there's no television cameras in the room?
Oh my gosh, yeah.
How do you think things might be different?
Well, in the first place, you wouldn't have had the weird beard. And the other thing is you wouldn't have had the contentious buildup of the advertising and the what have yous of against Judge Bork. In fact, I should tell you a quick aside. Whenever I run into any justice of the court, I say, they blanch when I say this, I got to lobby you about something before the court. And they say, what? I say, don't you ever allow television in the Supreme Court. That would be the end of civilized life as we know it.
Right.
So they all say thank you. It wasn't some case that was pending.
Right.
So no, I think there's too much overexposure. Sorry, media, freedom of the press, but there's too much overexposure. But they play to the look at the questions. Senator Biden went 30 minutes in his questioning taking up his entire time,
Right.
making speeches, running for president that one year against Bork.
Well,
I can't talk about today, but I can talk about 20 to 40 years ago. The senators with whom I worked on the Senate Judiciary Committee really cared about their role in governance. And they were very close to the Department of Justice. They were usually on the Senate Appropriations Subcommittee for Justice. They knew more about running the Justice Department than some attorney generals. I've served 8 attorneys general in one role or another, including Bork. But these senators cared in such a way that they had a stake in the outcome of the hearings. Now, Tom points out that he's never seen a senator lose back home because of their vote on a Supreme Court nomination. But they had a passion for victory. It was not easy with Carswell and Hainsworth, particularly Carswell, because he just was a tough nominee. And I'm saying that nicely. Powell and Rehnquist were quality nominations. And the 4 that Nixon got on the court were quality justices. Now, having said that, Eastland and Hruska and the members of that Senate Judiciary Committee that voted for those nominees felt as honored to have them on the court as the president did. It was a partnership. They were locked together with the Attorney General and the President. And it's just interesting to see how that plays out.
Fred, I was wondering, there's this reference to the greenhouse effect, right? So the greenhouse effect is this concern that once justices get on the court, they'll try to vote in a more liberal way to please Linda Greenhouse, who used to write for the New York Times, right? And during the Nixon years, it was known as the Georgetown effect, right? That they would be, they would drift to the liberal side. When you're vetting candidates, is that something that comes up? And what role does that play? And how not only confirmable, but how consistent will they be once they're on the court?
Well, as far as the vetting process, I mean, that's such an amorphous issue that it's very hard to predict, and certainly presidents throughout history have dropped the ball on that in their own minds, that they've miscalculated. But also, if you watch the court, a lot of what you called the greenhouse effect, I think, and you can reverse it and call it something else as well, I think you will find it's the cleverness of those sitting on the court and how they subtly influence each other and raving about a fine footnote, and then the next time that was a brilliant paragraph even though you disagreed with me, and the next comment might be something else. I think that is the more telling change element than the greenhouse effect.
Okay. And in terms of when you're focusing on particular candidates, we talked about Scalia and Bork. To what extent is ideology and electoral politics a consideration? I mean, for example, the appointment of Sandra Day O'Connor was thought to be an electoral influence decision, right? There was a gender gap that was exposed in the 1980 election, and there was an attempt, and Reagan made this promise to appoint a woman. Do those issues come up, or is that for someone else in the White House?
Well, they certainly don't come up in the conversation with the candidate.
Right.
But it was clear to us, for instance, that the president was looking for a woman, but not necessarily for electoral politics.
Okay.
He was looking for a woman because he thought that was something he wanted, all things being equal. But it certainly doesn't come up in the conversations with the candidate at all.
Right.
And yet, come on, everybody knows that a Democrat president is not going to nominate Nino Scalia.
Right.
I mean, the presidents will nominate people that reflect their view of the Constitution and the role of the court in interpreting the Constitution. and that's what elections are about, candidly. But so don't expect something inconsistent with a president's view in order to placate somebody. That doesn't happen.
Plus, along about the time that a president starts picking up some primary victory here or there, you don't think for 5 seconds he doesn't think about who he put on the Supreme Court. He has his friends, he has his allies. He knows, he has a thing in his head. You know, he knows who, and we all know, like Fred says, we all know who people are going to put on the court. What kind of, we don't know who President Obama is going to nominate. We know who Romney was going to nominate. But they have their own little secret list themselves, I'm sure.
Does that symbolism, you know, if it's a female appointee or Scalia, Italian-American, you know, those types of, you know, because senators are thinking in these terms as well. Clarence Thomas, African-American. Does that, when you have those that powerful symbolism attached to a particular nominee, I imagine that changes the confirmation process in some way, or is that not right?
Oh, sure does, no question. But it's up to the Freds of this world to do the, when they do the vetting, they're the ones that decide a little ahead of time. We do the second phase. Right. They do the first phase. The process of the gender gap, or the first black, or the first Italian, or the first Catholic, or the first Jew, or the first what have you, has already been figured out by the time it comes to us. But it does have an impact.
But and as Tom said, there are certain people that rise to the top of a list in either party and any candidate that you kind of assume will be. But to tell you an interesting thing about Sandra Day O'Connor is that came up in '81, so it was the first year. Right. And in the beginning of administration, of course, a lot of things have to be accomplished quickly. But that came up, and I had my list, if you will, and William French Smith, Attorney General, and I compared our lists. We hadn't before, and Sandra Day O'Connor was in both our lists. So.
That's interesting.
Yeah.
Think about this. Now, Fred correctly invoked executive privilege in discussing conversations with the president. But you don't get to be president if you're not political. And the last professor I can think that became a president was Woodrow Wilson. Now, these guys are really very much in tune with the country. And they're very much in tune with what the Senate is doing, because it's collaborative business. So every president wants to know what the votes are. And there's a fair amount of pressure that's put on us to say what so-and-so is going to do. Now, you take the nominees around, and you can prepare them, but if they're not social, it's tough to sell them. You put them in an office with the senator, and they look at each other, and they got to talk, and they've got to relate, and they're making friends. That's the first level of exposure.
That's right.
And every senator, and then you take the senators, and you can pretty well bulk them and know who's going to go with your nominee, and then you're working on the middle ground.
Right.
And that's where it gets a little tougher.
Yes.
So am I clear?
Is in terms of the more difficult nominations, obviously with Nixon, all of his are in the first term. And then the successful ones that we focused on with Reagan were in the first term. Bork is obviously in the second term. There's two things important with Bork. One, that it's the second term, but also that, as you mentioned, the Democrats take over the Senate. But is that second term more difficult? Do you see that as something that might be more difficult for a president to get a nominee confirmed because he may be on his way out, or is on his way out?
It depends on when it comes.
The first term, you may be on your way out.
That's true too.
It depends on when the vacancy occurs.
Okay.
You better get it done the first 2 years and a half, because a little later on, he ain't gonna run anymore.
Right.
And so we'll just wait, because our guy may get in.
Right.
And don't forget something. when Nixon first became president, it's the first time since 1848, Zachary Taylor, since both parties were Democrats. Both parties were not of his party.
Divided government. Right?
So he had a hell of a time he had the Southern Democrats, the boll weevils, as we called them, that helped out. But that is a factor that you've got to put in.
Right.
Is he confirmable? That's why the White House, when they came to me on Bork, I said, yeah.
Right.
And that wasn't good enough.
So are there people, have you gotten phone calls where they say, what about so-and-so? And the answer is no. He or she is not confirmable. That they just can't be added, or in the vetting process, they just can't be added to the list because it's just going to be too difficult.
They're usually taken off a list.
They're taken off the list, right. So, and in the confirmation process, does that come up where it's,
Yeah,
I'm sorry, but no?
we do it. They do it on cabinet level and deputy assistant secretary for widgets somewhere. One of the things is he confirmable?
Mm-hmm.
It's the same thing. It's not only that. The president, if he vetoes a bill, when I was in the White House, they used to send a memo around. They say, we're going to veto this bill. Can we sustain it? And you go back and you say, no way. It's a clean air bill. It's a clean something or other bill. Right. Sometimes the president will say, fine, I want to make a point.
Right.
So he vetoes it and loses 98 to nothing. Well, he's made his point.
Mm-hmm.
On the other hand, when a president vetoes a bill or when a president makes a nomination, the issue itself disappears because it is now the two branches either working together or fighting each other. As I said, the nomination of a Supreme Court justice is the biggest vote, short of war,
Right.
that the person will cast.
And I mean, recently, it's almost no matter who's appointed, there will be, with Scalia is confirmed with unanimous or 0 votes against. Ginsburg and Breyer, goodbye, with just single-digit votes against. But now we've come to the point where Roberts, who by virtually all accounts performed superbly, I think 22 senators voted against him. Has the Senate come to a point where, no matter who the president is, Democrat or Republican, an appointment to the Supreme Court is going to instantaneously attract 25 to 40 senators in opposition?
The short answer is yes.
Mm-hmm.
The Senate has changed. Comity is gone. Relationships are gone. Somebody asked me, I guess it's a year or so ago, a New York Times person said, you've been around this town a long time, what went wrong in the relationships? And I said, it's easy, they quit drinking. In my day, we cut more deals in back rooms on Vietnam War votes, this confirmation, that confirmation. The problem today is that the trust is gone between the branches, and that ain't good. Nobody trusts anybody's numbers. Nobody trusts anybody's points. The House doesn't trust the Senate. Senate doesn't trust the House. Nobody trusts the OMB. The courts are out there. It is not a healthy situation in which we find ourselves.
Mm-hmm.
Yeah, no, the end of
You can trust
comity,
one thing.
and it's everywhere. And the other thing is the breakdown of party discipline
Yeah,
in the
no
political
such
force.
thing.
There's no such thing.
But you can trust one thing. Every afternoon must end. And what we've seen today is what we fight and bleed for in these Nixon legacy forums. People that were there looking back on why it was done and talking in the discussion of what they tried to do, what went right, what went wrong, and what that means 40 years later. I thank you for coming. I hope you come to another or watch another one of our Nixon legacy forums. Good afternoon to you.